Welcome to today's webinar, Beating the DFARS 7012 Compliance Deadline. Okay, I'd like to introduce today's speakers, Scott Giordano. He is a privacy attorney with Robert Half Legal with over 20 years of experience. Secondly, I'd like to introduce Corey Rutherford, who is a solution architect at Spirion. However, he is a security practitioner in the area of data stewardship for more than 20 years. He was a Spirion customer and recently joined us. So welcome, Scott and Corey.
Fabulous. Thank you, Doug. Okay, so what are we going to talk about today? We're talking about all things DFARS 7012. So we'll dig into just what is implicated by DFARS 7012, talk about the relationship between NARA, National Archives, if you will, and CUI, Controlled Unclassified Information. We'll go in some depth in data discovery and classification and how that is used to address the requirements for DFARS 7012 and for other things as well. And then I'll talk about the road ahead and what we can expect as this regulation unfolds and is enforced over time. So, okay. So let's talk about exactly what is DFARS 7012. And I imagine everyone on the call here is familiar in some form or fashion with it. You may have heard it called different things because it's evolved over time. It requires two things for anyone in the defense contractor supply chain, from the primes all the way down to the local machine shop, basically. Provide adequate security, and I use that with quotes here because that's what they cite, and then notify DoD within 72 hours of a cybersecurity breach. This is a very aggressive requirement on the notification piece, simply because in many cases you may not have any useful information to share with DoD within 72 hours. So we'll talk about how you can obtain that. Really, from the perspective of DoD, the objective of the rule is to improve contractor security, because that is one of the many weak links in the chain. You can argue that federal agencies are just as a weak link, but put that aside for the moment. We really want to focus on contractor systems. So systems that are operated by contractors on their own accord. They're not operating systems for the government. Different discussion. The initial rule, which is called the final rule, which is ironic, initial final rule was published in 2013. There was two interim rules that were published in 2015 as a result of the pushback that the defense establishment gave DoD. And the final rule, or as I call it, the final rule, came down last October, so about a year ago. A deadline for compliance is the end of this year, and no, they are not going to be extending it.
So, Scott, this is Corey. I got a quick question. So I've noticed as we've had discussions about DFARS 7012, I've also noticed that it aligns, or it seems very similar to NIST 800-171 and other compliance type of rules that we're seeing out there when it comes to security and things like that. Can you generalize? Are they the same? Are they different? Maybe you can provide us some feedback.
They're not the same. Thank you, Corey. They're not the same, and this is a common misunderstanding, and unfortunately, DoD I think has perpetuated this. Is that NIST 800-171 is the standard that they point to in the rule, but the rule has a lot more to it than just 171. So, for example, you have what I call the non-171 requirements, like 72-hour requirement to notify for a breach. But there's also other things. You have to, for example, be able to segregate malware that you found on your network so that DoD can remote in and look at it. You have to conduct an investigation to get an idea of just how significant the breach was. You have to take the 7012 clause and make sure to push that down to your subcontractor. So there's a fair amount of non-171 requirements that get missed because everyone just presumes everything is 171, and it's not. So I'm glad you asked that. That's great. If we go to the next slide, I'll actually show it to everyone here so you can see just how we got here. Funny, people presume that this was just something that came down the pike last year. It started a long time ago. In fact, back in 2010 is when this whole show went on the road. There was an executive order, EO 13556. Yes, exactly. You can see the chart here. So back in November 2010, the president issued Executive Order 13556. This is the executive order on CUI, Controlled Unclassified Information. And just by way of a backstory here, at the time that this was issued, there's between 40 and 100 different acronyms that DoD used to describe what we now call CUI. So you think about it, you may have seen something in your tenure at your company called FBU, sensitive but unclassified. You may have seen things that were called FOUO, for official use only. I used to see that a lot when I was a defense contractor. The problem is that, what does that mean? I can't tell you what it means. Yep, I know it's sensitive, but is that classified, like in restricted, or is it top secret? It was unclear to everyone in the defense establishment what something meant, because there's no consistency. Hence why the president issued this order on CUI and said, okay, great, now we're going to call everything CUI that's not quote unquote classified. So top secret, secret, etc., that's classified. If it's not classified, it's CUI. It needs to be protected. Hence, that's how we got the start of this. Now, there's a couple different players in this. You had DoD, who's going to issue the DFARS rule, saying, here's how you're going to do things, defense contractors. You had NARA, who was the executive agent, saying, okay, we'll create the different species of CUI so that you had some kind of classification, as we'll describe later. You had NIST, who was putting together all of the security standards. So you had these three parties working together. And if you look at this chart, you can see that there's a lot of work that's going on in the background that most of you just weren't aware of. So if you look at the top part of it, you can see all the DoD stuff. You can see the DoD final rule, quote unquote final rule, that came out in 2013 that no one liked because it used NIST 800-53, which is really a high bar. So they went back to ground and asked NIST to have a different standard put together that was a little more achievable. If you look at the bottom of the chart here, you can see that NARA went to ground and started working on things back and developed something in 2011 that was a essentially initial implementation of this. So the idea of creating CUI categories, for example, that started back then and continued over time developing. You had NIST develop the first 800-171 version. That happened back in 2015. And in fact, they had another start, if you will, of this back in 2015, which failed because, again, too burdensome on defense contractors. They weren't happy with it. They pushed back and said, we need more time now. So DoD came back and said, final. Okay, final rule, 10/26/2016, that's when it's going to be issued. And you have to the end of 2017, and that's it. You're done. Get it done or else. So while they did that, NARA put together their final CUI rule, which created the CUI Registry that we'll talk about in a bit. So that's why this thing is so darn complicated, because you have these three parties trying to work more or less as a team and not quite getting there. Okay, so I hope that was enough backstory for everyone. Let's go dig into some of the details here. So we'll go to the next slide.
There's a question regarding the 72 hours. Is that from occurrence of breach, discovery breach, or understanding of breach? And our participant provides an example of experience, reminds us of Spirion and Yahoo in terms of time dependence of what is a breach. And a second part question I'm going to add to that is, what are the implications of not complying?
Okay. Well, I'll answer the first question first. In terms of when is it a breach, in quotes, which you guys can't see, but I'm using air quotes here. It's a breach when your organization determines that it's more likely than not that you've either lost data, meaning that you lost a laptop and all the contents on it, for example, or it's more likely than not that a third party has gained unauthorized access into CUI. So when might that take place? It's not going to be a breach when you have an event, okay? And those of you that you've got your folks in the SOC and you're watching these things come through all day long. People are pinging you and they're trying to break in and all that. Okay, not a breach. It's when you reach a point where it's more likely than not, and there's a consensus that it's more likely than not that you've actually lost data. A bad guy has got it, someone unauthorized has got it, or it's been lost. So I can't speak to Spirion and that whole story yet because it's still too early to make any judgments. What I can tell you is that you're going to have to just use common sense. If this is something that you'd want your customers to know about, that there was a breach in the data, then it's likely going to be qualifying as a breach. And as a consequence, you need to notify them and likely DoD as well at the same time. You can make arguments that you want to notify your customer first, but as a practical matter, you got 72 hours. It's a very short runway, which means that you need to be able to provide really good information and have that on hand for DoD and for your customer so they can start cleaning up afterwards. That's the best direction I can give you. There's not a bright line as to where you say it's a breach, ergo we need a report. Second question is about what's the consequences. We have a slide on here that talks about the consequences. So the short version is that there are no penalties baked into 7012 because there's all kinds of other bad things that can happen to you. You can be excluded from any future contracts, essentially being debarred. If there's a breach and you lost data, you can be subject to contractual penalties. Finally, if it's really egregious, you could be subject to a False Claims Act lawsuit from the government or from even a whistleblower, which is a big, big, big danger. It's happened, and it happens with regularity. So just some of the bad things that can happen.
And Scott, this is Corey. I wanted to ask maybe if you could elaborate a bit more. So this slide does a really fantastic job of explaining, where we got the standards. You can see there's a lot of NIST work that happened in the background, like you had already mentioned. Which led up to 2013, DFARS, the final rule. Between NIST and DFARS, we see the 72-hour response notification. We see it in GDPR and other groups and other compliancy requirements like that. Is there any guidance you can provide or maybe some insight on, the incident response time we know is 72 hours, but incident response time is just a little bit different from, you have to report this to the DoD after 72 hours. And then on top of that, if a breach does occur, there's a triage that has to occur. Do we have a time limit to do a triage internally before we have to start to work with other entities with regard to that, or is it 72 hours really means? And how do we triage data we no longer have, or just data we can't see the source data anymore? We just see the metadata at that point. Does that make sense?
Well, yeah, a couple things. 72 hours really is the deadline to get useful information that is actionable to DoD and to your business partners. It's important to have it ready for both. So in terms of doing triage, metadata can give you everything you need to know, quite frankly. And I'm a big proponent of metadata just because there's a lot of good material in there. If not surprisingly, if you use data discovery and classification, you should be able to just run a report and get an idea of exactly what was lost, because you'll have an idea of the repositories that were breached, or even if you have evidence someone was in the network in a particular subnet, for example, was connected to that subnet, what could they have access to, and really playing that what if game. And then looking at the repositories that are available and saying, okay, well, in this repository, we have all the diagrams, or we have all the blueprints, or we have all the reports, or what have you, or had them. They could have been destroyed at that point. But at least you've got a record there because you've done scanning and you've built up your inventory, your data inventory, so you have an idea of where things are. These are all the components you're going to have in place before you actually do a report. Otherwise, you don't really have anything useful to report on, and that's just going to make DoD and your customers angry.
Right, so it sounds like what you don't know, so there's nothing you can react to. There's no triage to be happened. So before I joined Spirion, security breaches or triages, potential breaches were always part of the equation because that's just the way security is. We adopted the Spirion solution because we had that ability to do a pretty comprehensive discovery inventory of all the data that existed on all our devices. We got the metadata back we needed, who owned the data, where it was located, when it was created, things like that, location of it. Is that a level of metadata that would help suffice the requirements for that?
Yes, absolutely. There's no question. When you have that level of metadata, you can run reports and get an idea of exactly what was implicated. Because again, you don't have to have all the information in 72 hours, but you have to have actionable information. Being able to articulate and give a very succinct summary of what happened is really what your customer and DoD is looking for. So they can say, okay, we know what happened now. We know that the blueprints to this program were stolen, or we know that this was taken, or we at least have an idea of where to start. So that's ultimately what needs to be done. And metadata, again, is a great resource for that.
Great, thank you, I appreciate it.
Okay. Let's go to the next slide, Doug, and we'll dig a little more into why 7012, okay? People ask me, Scott, is this a regulation? The answer is no, okay? It's unlikely we're going to see any more regulations on security or privacy anytime soon. We're already dealing with GDPR nationwide, and so I don't think we're going to see anything bigger. Where this comes from, though, is DFARS is from DoD's rulemaking ability. So imagine that I'm sending a contract request to someone. I can send all kinds of stipulations saying that if you want to adhere to this contract, you want to win this contract, you have to do all this, these items on my list. So you have 7008, which essentially point to 7012. 7008 says, go look at 7012 and make sure that you're willing to comply with that. So this will happen in a solicitation. It's very common for contractors to get solicitations way ahead of time to say, hey, this is coming down the pike. If you want to bid on this, here's what you need to do. 7012 clause typically shows up in the contract itself, and that's typically what I see, is you'll get a contract that says, sign here if you want to do this, and you've got until the end of the day. I've seen some really ridiculous things that subcontractors get from the prime saying, here you go sign this. And it's got a 7012 clause saying, here you go, sign this, you adhere to this, stipulate to this, that you're going to meet the terms of 7012, which again talks about adequate security and cyber incident reporting, the things that we've already described. So to whom does this apply? Well, not surprisingly, it applies to primes and it applies to subs. And if you're a sub and you have subs that you're going to be asking for work on this particular program, then you're going to have to push down the 7012 clause to them as well. And if they or you need a variant, say, for example, you're looking at your security regime and you say, you know what, we don't do multi-factor authentication and here's why, or we don't do this and here's why, you're going to have to push that back up to your prime or whoever's in your supply chain and say, hey, here's the variance we're requiring. Can we talk to the contracting officer and explain why? So that's important to be able to do as a sub. Now, I get the question, well, if I'm just selling COTS goods, commercial off-the-shelf prepackaged software, a la Microsoft Office or something like that, do we have to comply? The answer is no. This is an exception to 7012. If you're just selling COTS stuff, you don't have to comply with 7012. But what happens in many cases is that you're selling services to a customer in addition to COTS goods. So the services will be considered compliant, have to be compliant under 7012. Say, for example, that you're supplying help desk services. Well, potentially on the help desk, you're going to hear things that are about critical infrastructure limitations or weaknesses. Well, that's a CUI category. Therefore, that piece of your business is going to have to comply with 7012. So don't presume that just because you're selling COTS that you're not going to have to comply. And then finally, the question I get a lot is, well, we're not a defense contractor. I'm using quotes here. Do we have to comply? And as a practical matter, you could be in the defense supply chain and maybe you're not even aware of it. For example, if you're supplying to TRICARE, which is the medical system that DoD uses, guess what? You're a defense contractor. That medical data is CUI. Okay, it doesn't have to be about a defense program. Medical data in that context is CUI. So as a consequence, you do have to be compliant under 7012. In terms of other government agencies, guess what? All government agencies are now required to use 171 for their data that they're giving to customers, contractors. So they have to comply with 171 and they have to push that down. So as a consequence, you don't have to be a defense contractor in the near future. Right now, these are the ones that are the most likely to get this, but down the road, it's going to be all contractors.
So Scott, it sounds like what you were really saying there, correct me if I'm wrong, is that we, regardless of what area we're in, we have a definitive contractual obligation to customers, civilians or not, when it comes to this. And if that's correct, what kinds of challenges have you seen how this applies to this scenario? Are there cases that you might be able to talk about?
Oh boy, there's a lot. I'll tell you what. As we go through the deck here, I think that there'll be opportunities to go drill down to that in a little more depth. So let's do that as we go along here. How about that?
Great, perfect. Thank you.
Okay. So what is CDI? There's some frustration here because people say, well, wait a minute, is it CDI? Is it CUI? Is it CTI? And unfortunately, this was somewhat frustrating. Part of this whole business is that you have CDI, Controlled Defense Information, which includes, Controlled Technical Information, or CTI, which also is a species of CUI. So it's really driving people nuts because they're trying to get an idea of just what this stuff is. As a practical matter, whether it's CTI, CUI, CDI, the idea is the same, okay? It's information that requires safeguarding or dissemination controls pursuant to and consistent with laws, regulations, government-wide policies. That's what's crucial. The category name itself is less important than the fact it needs to be protected. So it needs two things. One, either it's got to be marked or otherwise identified in the contract, or it's something that's collected, developed, etc., by the contractor on their own. And here's the challenges that you as a listener are going to face here. If you're in the audience and you're interested in this, getting it marked or identified in the contract is tough. I've yet to see a prime contractor identify anything. They tend to leave it up to the sub to identify it, which makes your job way harder. Secondly, in many cases, you as a sub are independently developing this material. Either you're creating it on your own, you're leveraging things you already have. And so in that case, the question is, well, what qualifies? Is it stuff just in our engineering database? Is it in the product lifecycle management database? Is it in the ERP system? Potentially, it can be everywhere. That's the problem, is that if this information, this CUI, touches other systems or is accessible from other systems, then they're in scope. So it opens up the door for a huge scope. And this creates all kinds of headaches on the part of clients because the scope is much larger than they thought. But let's go to the next slide.
So Scott,
again,
it seems like the definition of CDI is well defined. Why is there so much confusion as to what is CDI?
I think that there's confusion because this process, remember, developed starting in 2010. And originally, they used different criteria. They used different terms. Like, I remember way back when it was UCTI. It was Unclassified Controlled Technical Information, and they dumped that. And they went to the NARA standards that we're using now. So I think the problem is that there was just a lot of development over time, and the defense community got used to certain terms, and now they've changed the terms, and I think that's created some frustration on everyone's part.
Got it, thanks.
Let's go to the next slide here. Okay, so here's the NARA CUI Registry, and I recommend, if you all haven't seen this, when you wrap up the call here, go take a look at the NARA CUI Registry, because there's about 84 different categories. And I know this screenshot here is a bit of an eye chart, but the idea is that there's all kinds of categories of CUI. And when you do a review in your system and get an idea of what kind of CUI you might have, you really want to give consideration to these different species of CUI. You just don't know what you have until you start digging. So if we go to the next slide, you'll see one example.
And Scott, so something that I've seen time after time with other organizations, and you'll probably talk more to this, the CUI registry, it seems like there were a lot of changes back then, and now those changes, those markings have become more stabilized. Is that true? Is that what you're seeing at this point? And if that's go ahead.
The answer is yes.
Okay.
The answer is yes. I think that we're done at the moment.
So one of the things that I've taken advantage of, because it does seem like it's stabilized, is because of all of these CUI registry, these acronyms, as you want to call them, I've been able to take the meaning, the characters that come out of that, and create dictionaries out of that. And I found it very useful adding it to various control devices. Spirion, for example, is a great example where we're able to get a list of all of the CUI registry, acronyms we're going to see, and put those within that for official use only, like FOUO. Taking that approach, is that an approach that you would recommend? Do you think that's a sound approach when it comes to?
I think it's a very good approach if you're working with business partners that are as savvy as you are, and have already done some of the homework. So if they have, then yeah, it's a brilliant way to go, because you're already proactively looking for things like that. I'm hoping that as we develop DFARS compliance, that everyone's going to take that proactive approach and say, you know what, I'm going to make sure that I'm embedding these markings in all the documentation we're doing, so that other systems and other partners can look at them and go, oh, okay, yep, I know exactly what this is. I know how it's going to be treated. And we'll actually show the audience, okay, this is great. So controlled technical information. This is the bread and butter kind of things that DoD looks for. So for example, blueprints, reports, diagrams, schematics, test results, all those things. That's a good example, things with military and space application. The marking is CTI. So in principle, you would mark this in the file name, so it's human readable. Also put it in the metadata field so that it's machine readable. That way, when your DLP system is looking for trouble and looking for things to enforce classification against, it'll pick this up. So this applies to any kind of CUI. So if we go to the next slide, and so you can see here's other species, export controls. So it'll have EXPT as a marking, or EXPTR if it's research. Typically that'll come from universities who are also subject to DFARS as well. So good example here, this is unclassified information, again, about things that are likely involved in export control, like ITAR and EAR series, what they call dual use items on the EAR side of things. So great example. Also, I know that looking for acronyms, I look for ITAR, USML for US munitions list. I'll look for EAR, I'll look for, sometimes we'll just mark it as DFARS as well. All of that is a way of saying, hey, it's export controlled. Let's go to the next slide. Okay, here's another example, and I just pulled this from the privacy category because I'm also a privacy practitioner. You can see that, say that you were involved in TRICARE, you may well be getting things like genetic information, health information, military or personal. If you're involved in FERPA for student records, you'll get student records. So these are kind of the markings that you will likely see, or you'll be embedding yourself using your own data classification system. So good examples of this and things to look for. Finding CUI in your system. Let's talk about data discovery, because there's a little bit of confusion about exactly what data discovery is. Data discovery really is a very organized mechanism for identifying sensitive information in your network, and I'll dig into it in a moment. I want to compare it with a couple things. One, data discovery is not e-discovery. I spent many years in e-discovery business. E-discovery really relies on building an index and then searching the index, which is nice, but that takes a long time. It's not real time, and it's something that ultimately is great for litigation, but it takes a little too long to really, in my view, be useful for data discovery for 7012 purposes. Also, you have the idea of file classification, and file classification is a information governance tool. So asking, well, how many Word documents, how many PDFs do we have? Which department is responsible for creating them all, et cetera, et cetera. Great example of that, and that is something that file classification does very well, but it's not really data classification. And then also, I get questions sometimes, well, is data classification the same thing as regex or just doing a Boolean search? And the answer is no, it's not. And the short answer is that regex is very nice, but it's not nearly enough, because it really is a very wide sweeping tool. It catches anything that matches a pattern, and it's not precise enough. Boolean is great as well. I spent many years honing Boolean skills, great as well, but again, it's not enough in and of itself. So let's go and really dig into this now. Okay, so accuracy is a big deal, and I'll give you this is a great example here. Say that you're using regex, and you're doing the old 4 + 4 + 4 before pattern to find credit card numbers. Problem is that anything that could qualify as that is not necessarily going to be a credit card. So if here you see in the diagram that it's a false positive in this case, where you found a pattern of that matched the algorithm, the 4 + 4 + 4 + 4, but it's not a credit card. And you can look by looking to the right of the little screenshot we have here, and you can see that it's not that kind of data. So it's very easy to match data, but to get lots of false positives, and after a while, it just becomes pointless to use regex. And again, I'm not disrespecting it, it's just that it's not precise enough. Before we go on, just 1.2 as well is that you want to be able to find things that have what they call bookends. So say there's a $sign or a euro symbol or a pound symbol in the front. Very helpful to get an idea, oh, hey, this is a this is a dollar figure. So if it matches that, then it's the kind of thing I'm looking for. So again, the kind of thing that Regex doesn't do a terribly good job of. So data classification. Here's what I would call the textbook definition of data classification. It's a process, and I emphasize the word process, of analyzing a document or a record and then applying a label so that you have an idea of who can access it, how it should be protected, how long it should be retained, how it should be disposed. So really providing all of the pertinent information about a document. Really, every document should have this information or have labels that indicate it, so you know when to destroy it, who should have access, et cetera, et cetera. And I emphasize the word process because this is not a one-time thing. You'll develop this methodology over time because think about it, you've got a set policy. The government has a policy to protect CUI, that was the EO 13556. Then you have a list of expectations, things that you've got to do. You've got the controls in place to be able to stop the bad things from happening, to enforce your expectations. And these things all have to work together and have to be developed and implemented over time. So as a consequence, it's a process. It has to be repeatable and defensible in the sense that you have to be able to, if you get into an investigation with DoD, say, hey, look, we did everything we could that was reasonable under the circumstances. Also, there's always a lawyer, as the joke goes. Unfortunately, or fortunately, depending on your point of view, much of this requires involvement with your legal department. And in fact, that's how I got started with data classification, is that someone came into my office, who was actually the CISO, and said, hey, we need someone to develop a data classification system, and it's got to be you because no one's going to listen to us because we're not legal. So that's how that happened. And as a consequence, I spent about an hour every day in the CISO's office just on this and other information security issues. Okay.
Scott, if I can interject,
sure,
one of the great advantages, and I think you're probably going to get into it a little bit here, and I'm sorry to steal some of the thunder. Before joining Spirion, one of the challenges we had was being able to identify the sensitivity of our data within organization, and data classifications were of extreme value to us. And part of the reason for that is, we had a method finally, a great method to have an early warning system, to notify us or others, when data is being moved from one place to the next. We could get an email notification, things like that. And that really is what drove the decision, to kind of go into the Spirion direction, because it just kind of matched with the types of data sensitivity that we were working with and the types we were looking for. And I think that's what, I think being able to take inventory and then applying a data classification around that data really sets you up for success, regardless if you know what the specification requirements are of DFARS or whatever compliancy you're trying to work toward. I just wanted to add that, and that's been in my experience quite valuable.
Yes. Well, and really data classification for me was a logical extension of all of the requirements we had in legal anyway. And there was never anything to tie them all together. And really data classification did that extraordinarily well. And I developed an entire data classification system for my former company. And it really incorporated all kinds of things that you had to do, but there was no other way to really do them efficiently. So yeah, I'm entirely in agreement.
Yeah. Question from a participant.
Sure.
Is compromised encrypted data a data breach? For example, lost encrypted laptop?
Oh boy, I get that question all the time. Ultimately, it comes down to how capable or how easy it would be for someone to defeat the encryption. If it's not terribly easy, then the answer is no, it's not a breach. And in fact, in many cases, for breach notification laws, you'll have a safe harbor, if you will, saying that if the data is encrypted, then you're okay. And the reason that I'm not going to give you a definitive yes on this is because you may ultimately have a very faulty encryption scheme that just relying on, for example, whatever came with the piece of software and not really looking how thoroughly well it was implemented or how you tested it. I mean, I guarantee that very rarely did anyone actually test encryption to see if they can break it. I don't mean breaking the algorithm, but I mean looking at weaknesses in the implementation of it. Because remember, data has to be decrypted at some point to be useful. With a couple exceptions, that's almost universally the case. So the question is, great, when it's being decrypted, how is it being protected? If that was stolen at a decryption point, then you're out of luck. So the short answer is, yeah, you likely have a safe harbor, but really check and see how effectively that encryption regime was implemented, because that's really where the war is won or lost.
And could it vary? Because another participant comments, that's not correct if you have data on a resident in the state of Tennessee, as an example.
Okay. Yeah. I mean, ultimately, you're going to have local regulations that are gonna say yes or no. I know at least one jurisdiction had a encryption safe harbor that they dumped later. Okay. I want to say it was Nevada, but I'm not 100% sure. But the point is that, and this is my advice I always give clients, is don't rely on encryption as a safe harbor. Really, even if your data was encrypted and it was still stolen, the laptop was stolen, I really would, because I would want to know if my business partners lost my data, even if it was encrypted. I still want to know. That way I can at least have the option to advise my customers and say, look, we don't think there's anything to worry about here, but here's what we recommend you do. Or at least launch an investigation and get an idea of what may have happened. I'm not a big fan of saying, oh, it's encrypted, don't worry about it.
Right.
Just based on experience, it's just too many ways to get it wrong.
Right, absolutely. And I've been in situations where I'm working with legal counsel for various universities where a laptop has been lost. Faculty was working on IP type stuff, research for a university. It may be encrypted and things like that. And one of the things that really helped us through the triage process was, having that inventory of what really was on that device. And again, we're talking Spirion. So, I mean, just as long as you have an inventory of what types of data are on that really does help. And the discussions that you would ultimately have that could last for weeks is reduced significantly when you're in a process of triage and things like that. So again, being proactive with doing your data discovery.
And having reports available that you take a snapshot of periodically, and so if someone says, well, give me a snapshot of what kind of data was on that laptop. Great. You have a report, you can push it and say, well, you had this, you had that, you had that, and the last date was updated was this. Great. At least you're giving that person useful information, because a lot of times that will defuse the situation. If you at least give them actionable information, they can send that up the chain. But telling them you don't know is the worst thing you can say. It's just, it definitely will get you into trouble. Yeah, and ultimately this is what's going to happen, and I'm kind of alluding to what I said earlier, is that you're going to have to walk in a legal's office when something happens and say, okay, what's our definition of a breach? And legal either should have a pre-planned definition, or if not, now's the time to call your inside counsel and ask them and say, what is our definition of a breach? What criteria is involved? You want to have something that's consistent, so that even if its laptop is stolen and it's encrypted, you may want to say, look, we're going to consider it a breach, but that's per policy, and that's something that the CISO, the GC, the compliance officers, they've agreed upon all of that. You have to have that consistency, otherwise every breach is going to be a fire drill for you, and it's going to be a disaster. And I've seen it happen, and people are chasing their tails when they should be providing good information to the customer. Yeah, I mean, I could wax poetic on this all day, but let me talk just briefly about what is data classification. We'll show you an example of a scheme that I put together. So it really answers questions like, what do you have, where is it, who has access, how is it controlled, so all those whys. And it's going to create consistency, which you need, so that, as I just mentioned earlier, if you have a breach or you have a regulatory request, that you're getting consistent information and you're giving it to those parties every time. And also, it gives you the ability to justify the controls you want to buy. If you say, you know what, we think that based upon all of these requirements, that having this set of controls is the highest bang for the buck. Because these risks are so high, these controls are most appropriate, and prioritize that. Everything has to be risk-based. In any regime I've ever seen, GDPR or DFARS or HIPAA, it's all risk-based. And it means identifying the risks and then saying, yeah, these controls get priority because they'll cost-effectively mitigate the risk. And again, when you do get the breach, you need to be able to prioritize your efforts. And as Corey's alluded to a bunch of times, triage is everything. Saying, okay, we think that this is the most likely candidate for the breach, and this is what it looks like. Get it to the customer ASAP, get it to DoD, get it to a supervisory authority. It may well be that you have to report to the state attorney general's office. Okay, great. Providing them with actionable intelligence is huge.
And knowing the sensitivity of the data that you're working with, data classification helps you understand that, rather than if you've got a loss of data or breach, it could be a very, very low public information, but you don't know that. You don't know the extent of the breach, the sensitivity of it until you've been able to wrap a data classification schema around that and understand where it is.
Yes, exactly. And in fact, we'll take a look at that right now. I think that on the next slide here, we've got the sample scheme. So let's see. Yeah, part of the process, and this is something I recommend everyone. Go back one, Doug. The process really has 4 components. It's got the matrix that Doug just showed you a second ago, and we'll dig into. It's got the matrix, and it's got a policy, because you always have to have a policy. If you don't have a policy, you're not going to know what you need to do. The policy is going to cover all the whys and wherefores. Then you'll have a tool set like Spirion or what have you, plus your DLP that works to enforce it. And then you'll have the monitoring and the audit mechanism. You'll have early warning mechanisms and triggers and reports and things of that nature to get an idea of whether it's actually working or not when you do an audit. So let's go into the matrix itself. So if you go to the next slide, you'll see that this is what a matrix can look like. And it's this is a subset of a much larger matrix I developed. It was just giant, actually. And so you can see here different categories here. This is a 4 category. You can have as many categories as you're willing to tolerate. And really, if you look in the middle of this where it says severity of the consequences, you can see how likely it is that something significant is going to happen to your company. From that point, then you'll work backwards and you'll say, okay, what qualifies as that significant damage? Well, certainly personal information or CUI would qualify as that. And so I'll make that the red category, for example. And I'm going to put this set of controls. I'm going to put no transmission via fax, restricted to named individuals, et cetera, et cetera. And the idea is that you want to have a set of controls that's finely tuned for that category. If it's unclear as to what category it applies to, you probably haven't finely tuned up the controls enough. So you're going to have technical controls, you'll have administrative controls, you have logical controls. It's just a question of how appropriate it is for that category. And here's the example I always use because I think it'll resonate with the audience. Is originally I had attorney-client privilege information as category red, category 4 basically. Problem is that meant that no faxing. And if you have any attorney colleagues, you know that attorneys still love to fax things. And the problem is that faxes can show up anywhere. And believe me, I've seen all kinds of stuff show up on fax machines that just were spitting out of the fax machine and no one was controlling it. It's one of those things that you don't want to say no faxing because attorneys love to fax stuff. They're not going to follow that rule. Why even put it in that category? You're better putting it in category 3 and having better faith, if you will, faithful control than having no control. So that's why you really have a political decision here on what qualifies as red versus yellow and so forth, and what controls you're willing to accept if not tolerate. So if we go to the next slide here, you'll see that I've covered other media. So you can have email between company offices, email sent outside the company office, electronic file transfer, web portal, so different media, and the list goes on and on. The idea is that you're going to have different controls for based upon the media, and it's tuned to that control. So this is why this is a fairly intensive effort to develop this. It's not a one-person job. You're going to have IT security, you'll have your compliance folks, you'll have legal, not surprisingly, leading this likely. I think we had on my team probably a dozen people, both US and non-US folks. So it's a big effort, but it's a big payoff. If you go to the next slide, you'll see that we also have examples of what documents might look like when they're tagged. So you can see that just at a metadata view, towards the bottom here, you're seeing documents with different color tags that are indicative of the different data classification that they're under. So great example of that. And this is real stuff. This is what you'll see on Spirion.
And
so, yeah.
And just to reinforce what you're saying there, Scott, it's all right. In the real practical world, before I joined Spirion again, this helped quite a bit with our security awareness and training aspect of our program. One of the most challenging aspects of meeting DFARS, is going to be the awareness and training component of it as well. So the people that are working, your information workers, are going to have to understand the types of data they're working with, the classifications. So through, like Scott had just talked, when Spirion, when we adopted this and we used it with an organization, people would recognize colors, and by the colors they were able to actually recognize the sensitivity of that file, and they would take a second look at what they're about to do. Am I going to copy this from an approved location and move it to my laptop to take home and things like that? So just by adopting that program like that, or some technical control around that, you're actually also adopting a security and awareness, and it becomes a very useful tool to help inform your information workers and to educate them just through a due process. And we found that very valuable.
Oh, that's great. And it's interesting you mentioned that it really helps with the awareness, because I'm a big fan of training and awareness, because really the best information security tool ever invented is an aware employee. So that's great. I'm glad to hear that. Okay, so why is it critical? Here's a great example. I'm not picking on a particular political figure here. This is just an example of how anyone could get in trouble. This was back in 2003, where you had this PowerPoint deck that had all these names, social security numbers, and it was embedded in the deck. So if I'm sure everyone on the call here is familiar with OLE, object linking and embedding. We've probably all been on the recipient end of this, of finding out that we just sent a spreadsheet chock full of valuable information. This is what happened, is that the governor of Florida, Jeb Bush at the time, sent this spreadsheet. He was very big on emailing constituents, which is great. But the problem is that it had all this information that was embedded in it. And this is something that I'm sure has happened to all of us at some point. It can happen to anyone. Being able to have that data classification discovery mechanism catch things like this before it escapes is crucial, because it's a big embarrassment. And again, it can happen to any one of us. Let's go to some closing thoughts here. And I'm sure we've got plenty of questions, Doug, but let me just give a couple closing thoughts here. I'm sure, Corey, you'll have some as well. Data discovery and classification is a core component of any global privacy and security program. I emphasize privacy because of GDPR now. Those of you on the call that have to deal with that know that it's a huge effort. It's really your first line of defense, because you have the ability to look at things and say, okay, I know right away that this is something that needs to be protected in a certain manner, just by looking at the file and looking at the tag, for example. And your information security system is aware of that. It's talking to it. And then finally, if you're a data protection manager or a data protection officer, this is golden, because you're having the ability to look at metadata and saying, okay, I know where all my Article 30 personal data is in a network, and I can identify it and print out a report and share that with a supervisory authority. So those are my thoughts. Corey, I'm sure you have thoughts and probably have things you want to talk about.
Yeah, just a couple things to leave everybody with. This mirrors exactly what you're saying, Scott, and your theme here. The compliance guidelines around anything that we deal with out in the real world aren't always to a level that we can look at and say, okay, we know exactly how we need to challenge it or how to technically address this. I'm thinking from the technical aspect of things. And just in my experience, the two things that always have led to success for any organization I've worked with or talked with and things like that, and my own personal experience, is you really got to understand where your data's out to begin with. You can't do anything until you know where your data's at. You can't make informed decisions. And the discovery process that Scott's talking about is just so valuable. Just having the audit, understanding where things are is just the utmost importance. And with that, then you can start to get into a more informed role where now you know where your data is at, you know what type of data it is you're handling. Now you can start making decisions on how to classify it, group those different types of data. And what that does is that allows you from a high-level decision-making process to then say, okay, I'm going to take and challenge and go work on the highest sensitivity set of data out there. We need to tackle this first, because we're all going to have different levels of sensitivity of our data, but where do you start? It's a hard decision to make if you don't know where your data is, the types of data you're working with, and certainly your data classification. So overall, if you can group classifications and create that awareness around that, the security, the end user awareness around that, you're going towards success. You're working towards DFARS or GDPR, even though the technical stuff that we are looking for is not necessarily there, but we can at least start working towards that by just doing those two things alone. And that'll get us in a position where we can technically adapt to the changing paradigm as that information becomes more aware or available to us.
Yeah, excellent. Yeah, well said. I agree. Doug, are there any questions for us?
Someone did ask, does Spirion work for cloud-based SharePoint document storage? And I answered the question directly, but Corey, if you want to expand on that, you're welcome to. If not, that's fine.
Yeah, absolutely. Yeah, Spirion has very good integrations into Exchange services on-premise or in the cloud, O365. It has great integrations into database systems and things like that. If you've got an OLE or ODB type system, we can definitely tie into that, and we can do data discovery through those various mechanisms. We tie into a lot of cloud provider services, such as Box and various other ones. We already talked about O365 and things like that. So yeah, we've got great and fantastic integrations. And we've got a lot of really good information on Spirion.com if you wanted to get more information about that, and you can contact us through that.
Great, thank you. So I don't see any other questions. I want to let everybody know Scott Giordano's contact information is on the screen if you'd like to send an email directly to him. He's provided us his contact information. And I'd like to thank you again for joining us and taking time to hear today's webinar, and I hope to see you in one of our upcoming webinars. Thank you, Scott. Thank you, Corey.
You're most welcome. Thanks for having me.
Thanks for everybody joining today.